Today on BenchBriefs, we're looking at a case that dives deep into the balance between administrative delays and the right to a fair process. It's Blencoe v. British Columbia, Human Rights Commission, a 2000 Supreme Court of Canada decision that asks, when does waiting too long in an investigation become unfair, and can it actually violate your rights? The story starts with Mr. Blencoe, a public servant in British Columbia. He faced allegations of sexual harassment, a serious accusation that triggered an investigation by the British Columbia Human Rights Commission. Now, investigations like these are crucial to ensure workplaces are safe and respectful. But what happened next created a real challenge. The complaint process dragged on for several years, and during that time, Blencoe experienced significant personal and professional distress. Imagine the stress of being under a cloud of serious allegations, with your reputation and career hanging in the balance, while the process just keeps moving slowly. Blencoe argued that this delay wasn't just inconvenient, it violated his right to a fair hearing. He said the drawn-out process caused irreparable harm, damage to his reputation, to his career, and to his personal life. He claimed that the delay itself was so unreasonable that it denied him the procedural fairness owed to him. More than that, he asserted that the delay breached his rights under the Canadian Charter of Rights and Freedoms. Specifically, he pointed to protections against arbitrary state action and the right to a fair process. So, the Supreme Court had to ask some tough questions. Did the delay in the administrative proceedings amount to a breach of natural justice or procedural fairness? Was the delay so unreasonable that it effectively denied Blencoe a fair hearing, and did it infringe on his charter rights? The court's analysis started with the nature of the delay. Administrative processes, especially those involving human rights complaints, often take time. Investigations require careful fact-finding, and fairness demands thoroughness. But there's a line where delay becomes unfair. The court recognized that delay can be harmful, especially for the person accused, because it prolongs uncertainty and stigma. However, the court also noted that not every delay is automatically a violation of fairness. They looked at the reasons for the delay, whether the delay harmed the fairness of the hearing itself, and if the delay caused actual prejudice beyond just the stress of waiting. In Blencoe's case, the court found that the delay was indeed lengthy, but it was largely due to factors outside the Commission's control, including the complexity of the case and other systemic issues. More importantly, the court concluded that the delay did not actually prejudice Blencoe's ability to have a fair hearing on the merits of the complaint. The evidence wasn't lost, and the fairness of the hearing itself wasn't compromised by the wait. As for the charter claims, the court was cautious. The charter protects against arbitrary state action and guarantees fair processes, but not every administrative delay rises to the level of a charter breach. The court ruled that the administrative delay in this case did not amount to arbitrary state action and did not violate Blencoe's charter rights. Why does this case matter? Blencoe v. British Columbia, Human Rights Commission, sets an important precedent on how courts view delays in administrative justice. It recognizes that while delays can cause real harm, not all delays are unfair or unconstitutional. The decision draws a careful line, emphasizing that the fairness of the hearing itself and actual prejudice must be considered before declaring a process unfair. This case reminds us that justice delayed is not always justice denied, but it also underscores the importance of timely investigations to protect everyone involved. For complainants, it means their concerns must be addressed without unnecessary delay. For respondents, it means they have a right to a fair process that isn't undermined by prolonged uncertainty. Thanks for listening to BenchBriefs. Join us next time as we explore another case that shapes Canadian law and impacts lives. Until then, take care.